Hello everybody, this is TJ from urlaw.org, and with this video we're going to talk about turning your common law arbitration into results. Now, there's been a lot of instruction out there lately about common law, thanks to things that we've put out there, thanks to things that Eon and others have put out there, and we just want to give a big thanks for the information that they've also supported in helping develop this. A lot of people are going out there trying the common law approach using common law arbitration. It's a specific process where you establish a private contract with a party coming against you for something, perhaps a foreclosure or a collection or even a criminal matter, and you're simply wanting to stop that and keep it out of the court system, or at least draw it into your common law arbitration arena, where it can actually be settled before it's brought to the public. Even if it's an ongoing matter, it could be potentially put into arbitration. But of course, you don't want to wait till the last minute, then it gets very difficult. So our goal with this video is not to tell you how to do that process. We have separate videos for that, particularly in our premium member area at urlaw.org. If you're not a premium member, be sure you sign up when you get to the website. But we want to talk here about how to monetize, how to get results with these arbitration awards. A lot of people are getting the awards, but then they say, well, now what do I do? You know, is it going to stop the foreclosure? Is it going to get somebody out of jail? Is it going to prevent a case from going forward? Is it going to stop a suit? So let's talk a little bit about that. So once you complete your common law arbitration, where you send it to an arbitrator, they do an administrative process, they review it to make sure and certify it to essentially make sure that it's a quality, good standing contract and that it's valid. Well, at that point, you've won an award, and typically it's triple damages for whatever there was charges were being brought against you in a dollar amount. Say if it's a mortgage of $300,000, it might be a $900,000 triple damage award. So what do you do next? And I'm going to remind you, nothing I'm about to tell you is legal advice. These are just our opinions based upon ideas, based upon experiences, based upon listening to others, as to things that you could research and try. But as always, seek competent legal counsel or tax counsel if you need it. You really have to put your thoughts and energy behind this. So again, you get to the premium member area, we have an arbitration training page. If you're a paid premium member, you'll be able to access those pages. And read all the various links that we've created a few times regarding the Arbitration Act and Supreme Court rulings. Remember, once you have won your award, this is just basically what you'll find in the law, their court lacks jurisdiction to proceed. Isn't that what we're trying to get? We're trying to get out of their jurisdiction. Well, one way to do that is establish that it's already resolved via arbitration. That puts the court into a position of not being able to basically make a ruling. Okay, so you'd file a motion in that regard. Now, if you don't know anything about motions and procedures in the court system where you might still have to use that, even bringing this in, you might want to take a look at our course. Not our course, it's a third-party course that we recommend people to. The link is urlaw.org/JD. urlaw.org/JD. Now you can expect when you do this process, you're going to get pushback and objections by the opposing attorney. Expect that to be their first move. So you have to be ready for the next move. So when you get to our website, and you're in the premium member area, you'll want to just pay attention to the page where we have a lot of these links here where you can download and read these different rulings, because this is all the information you could use in your motions and so forth. But you need to understand the foundation for arbitration and why you can do this as a remedy for your situation using the public courts without going into the public courts. If you must bring an arbitration result in the court, you'll need these references in your pleadings. You might have to put a motion in to dismiss or something along those lines, or to take notice of something. So if you want details on premium membership, go to urlaw.org/join. Now, once you win your award, it's important that you create a record, a public record of the private award. Because remember, this arbitration award is done via a private agency who reviews it and certifies it and says this is legitimate. But how do you make sure that it can be seen and used in a public matter that you might have going on? Well, you got to create a public record. So once you create a public record, then that becomes evidence that you can use from that public record. So the court has to realize it cannot interfere with other judgments. So we need to make this appear as any other judgment would on the public record. But if it's just happened over here in the private, they're going to try to do everything they can to ignore it because they know you haven't figured it out yet. So what you have to do is figure it out. You need to record that arbitration award, and I've seen most people do this successfully via a notice of foreign judgment. It's just a simple, motion or notice for foreign judgment looking like any other court letterhead with the judgment information listed there and the attached documents from that award. All the attached documents get filed. Now, the federal court is, I found to be one of the easiest ways to do this. Your local federal court building, go to the clerk, open up a miscellaneous filing. Usually that costs $47. And what you're going to file in is a simple one-page notice of foreign judgment. Cite the judgment award as it's been listed. It'll have a registration number. It'll be certified, and the attached documents. Put all that into the record. Now you've created a public record. Once something is in public record, it is now admissible evidence into other things. So you first got to create that public record. Now, if you have difficulty and that doesn't work for you, you can file a notice of foreign judgment in your local court or county recorder's office. Wherever you can get it into the public record, that's where you want it. And then remember, you're just telling them you want to notify them of a foreign judgment. They can't make it an excuse for not recording it. It's already a judgment. And now the other way you can do it is go to Lamar County, Georgia. You can look them up on the internet, and they're pretty easy about recording documents into the public for you. Then, once you've recorded this in one of these locations, you obtain certified copies back out. Usually that takes a few days before they'll be ready to certify them. Those certified copies now are really powerful evidence that you can use. Let's say if you've got a foreclosure suit coming against you, you could bring it into that suit right away as evidence that the matter's already resolved via arbitration. Or other scenarios where something's ongoing or already passed in some cases. All right. So then once you've got those certified copies, you've got a weapon in your hand. This is now a publicly recorded foreign judgment, and other courts cannot interfere or dispute what that judgment says. And if you see the criminal complaint version of the arbitration system, you'll see that it's very powerful in terms of what it says, what position it puts the other parties into, and now you have an opposing judgment to their judgment. Now, let's say you bring this to a court, and basically they interfere. The judge interferes, the attorney tries to stop you, and so forth. They play their little magic game and try to get you off track. Okay, maybe the judge has no jurisdiction. I'm going to just fix that spelling. To interfere, they simply cannot interfere with another judgment. Those are the rules. Sorry, I didn't make them up. So this is why you need to record it somewhere first and then bring it in. It'll have more standing. It'll be something they can't keep out. Now, if they still interfere, you could consider a complaint to the Bar Association against the attorney bringing it, or even the judge who is interfering. They're interfering with another judgment. They don't have jurisdiction. That's serious business. Go look up their rules. Don't take my word for it. I'm not telling you to just go do this. I'm telling you to research doing it. Plus, you can even then go to find out who their insurance carriers are and put in a claim for damages. And believe me, when they get a claim for damages against them, you get their attention. But it's got to be legitimate. You have to pre-establish it because they're interfering with another court's or another jurisdiction's actions. Remember, that jurisdiction is supported by the private arbitration and now whatever court recorded it. Okay? And if you have to, you could also research our void judgment course on maybe some ideas that you could exercise there as well. I'm not going to tell you how to do that. I'm just telling you where to look and let the ideas come to you. Now, you could also research a motion into the local court to take notice and confirm your judgment. after it's all there. You bring it in as evidence. You file a motion to confirm. And then you ask the court to issue a writ of execution for you. That's an order to go collect. And of course, you can expect pushback back on that, but don't just say because it's hard, I'm not going to try. Go research it. I'm not telling you to do it. I'm not telling you to do anything. Then research the possibility of filing a UCC1 and then a UCC3 into your local county recorder. UCC3 is the instrument you bring a UCC1 under to record property. See, what you're doing is you're going to outline the award. You essentially are the creditor in the award situation. The losing party is the debtor that's owing some money. Now, this creates a lien against the property who just lost. And of course, once you record the UCC3, it goes into the public record. UCC1 puts it into the state record, but the UCC1 puts it on the property record as well in your county. Those two together are very serious business. You will get contacted by somebody once you do this, so make sure you know your local rules, your procedures, and follow those accordingly. And once you've established this, remember you have a valid contract. Nobody can dispute it. Then, if you're going to maybe do something we're going to suggest later, which is to sell your award for money, that the fact that it's been recorded and so forth adds value in terms of the marketability of the instrument. Because you've successfully gotten it recorded into a general court, and then you brought it into a specific location like your local county, that instrument starts to have serious value in the secondary selling marketplace. I learned this because I started in the mortgage industry some 25 years ago, and the very first thing I did was buy and sell some paper. And I figured out how all kinds of paper have value to be sold. There's many kind of buyers for many kinds of paper. This is a property paper. A contract is property. A contract that's certified and adjudicated is worth more than one that's just a piece of paper. So what you've done is you've created value for the paper, if that makes any sense. Again, this is the kind of stuff we get into and discuss in our weekly calls for premium members. So if you're not getting all of it right now, we can generally have further discussions on that in our weekly calls. So be sure you're checking those out as well. Now let's talk about the various ways which you might exercise or monetize this. And this is by no means a comprehensive list, but let's say, for example, especially if you're dealing with foreclosure or a lawsuit that's coming against you, or somebody's really trying to collect hard, maybe even if it might even be a tax situation. Again, this is not tax or legal advice. I'm just telling you, look at Chapter 13 bankruptcy. And what you do when you do a Chapter 13 is you've got to list assets and liabilities. Maybe you've already started a Chapter 13. Well, you can always do an addendum to your asset sheet. What are you going to add on the asset sheet? You're going to add the deposit of the contract award. They ask you for your judgments and things like that you're receiving in Chapter 13. So you need to report it. We're telling you to make sure it gets reported. And of course, you can supplement it with the copies of your certified copies that you obtained. Not to be the originals there as necessarily, I don't think. It might be. You have to look at the rules. But the bottom line is that your certified copies need to show up there. Okay? And let that stand as an asset sitting in the record. Then you're going to instruct the bankruptcy trustee, who is supposed to be doing the accounting, that's his job, is accounting, to use the contract property to set off any other valid paper claims. So if there's a mortgage lender there, number one, you could be doing all the challenging that we just commonly discuss in our mortgage classes for challenging a claim in a bankruptcy. But on top of that, say, well, if you do happen to get the claim through, which if you stand your ground, they never really should, but if they did, you're telling them take the asset and use that to set it off. You're coming into the court with assets to settle it, not to just go in there like a typical bankruptcy debtor who doesn't want to pay. You've deposited the assets to settle everything. Remember, they're just doing bookkeeping entries in their fiction money counting system. So let them do the counting and set off one side of the ledger with the other. They have the ability to monetize by the issuance of simply an accounting entry. At least that's how I understand it. This is just the idea we're approaching, and we certainly have people that are out there giving it a try. You won't know if it'll work for you until you try. Don't call me and ask me what percentage of people do it, because not everybody tells me what they're doing or every detail of what they're doing. We don't know. You just have to see if this makes sense and then follow through with your instinct. If you're in a foreclosure, again, a Chapter 13 will help stop the foreclosure. If you wonder, how do I stop the foreclosure? You can, of course, use bankruptcy if you haven't abused it before. And then again, do the same thing we just discussed. If you need to use that to just slow things down, you might also have to file what's called a lis pendens. Okay? And what that is a action which essentially is a notice that you're about to file a suit. When you give notice you're about to file a suit, that can go out there to the public, to the sheriff, to the other court, or if it's a non-judicial state, the parties that are trying to foreclose, and let them know there's now an action pending. That usually stops the foreclosure action. Then the quiet title action is there to call in all creditors and see who has the most valid claim to the property. That's what you're doing. You're quieting the title. But what we're proposing is a little different kind than you typically see out there. Most quiet titles are based upon, securitization and all that, and we've seen only limited results with that. But what we're suggesting is you bring in your award when you file your suit. Again, when you bring coming in as a plaintiff, a regular old plaintiff, you're coming with clean hands with an asset and putting it up and saying, hey, I'm putting this up as collateral. If you can prove your claim, the property's yours, but you need to take this collateral and also settle it. So again, you're offering, yet kind of like a bankruptcy, you're offering to do accounting and settlement, not so much just fighting. Only if they can bring a valid claim, and typically they really should not be able to, but if they did, let's say it was a tax bill, no, that's for real estate. Never mind, that's totally different situation. I mean, sorry, that's for taxes, not real estate. Disregard that. But if it is a mortgage, you could offer this as a way to settle it. So you're coming in with two remedies in each of these situations. Okay, one is, of course, just prove a claim if they can, and if they can, settle it anyway. Set it off, do the bookkeeping entries, and that's it. Now, if the judge further ignores you, I talked about previously about putting in a complaint and so forth, but if the judge ignores you, put in a judicial notice of the Supreme Court rulings, the Arbitration Act, and Administrative Procedures Acts. Again, we have links to these things on our premium member page. So you can use some of those references or do your own research if you want to. It's out there. Nothing that we're giving is top secret. We just make it convenient for you. Plus, you could do a motion for findings of fact and conclusions of law, basically telling the judge he has to state why he can ignore Supreme Court decisions and those two acts of Congress, which of course he cannot do. He may try. That's why you put up these motions. The motions are how you challenge these things. Expect these pushbacks. Now, other thing you could do is you could consider a motion to the court to take notice of the foreign judgment and seek a certification and authenticity. You want them to authenticate the judgment. Now, they may be reluctant to do it, but you've got to, if you put a notice or a motion in, put this case law in. We give you plenty of those links to use. And tell them that you're really compelling them to do it. Okay? Bottom line is the court lacks jurisdiction to rule against an existing judgment. They can try to relitigate what was already litigated, but they really just can't do that. They'll try. If you let them, they may get away with it. You got to know the rules of the game. Now, it's kind of like playing football. There's they only get 3-4 downs to get a first down, and then that's it. You got to tell them that. Now, after 90 days, let's say you've got the award. It's 90 days later. The other party has not responded or done what you've asked them to do. You could declare. And again, this is not a tax advice situation. You need to seek a tax advisor on how to do this. But you could declare the award as a loss. So let's say it's a $300,000 mortgage, but it's a $900,000 award, and you cannot collect it. You could set that document up as a deductible item spread out over several years. That's called a loss carry forward. Go research that. Don't take my word for it. But basically, it becomes a deductible triple damages award that you can collect over several years. You're going to collect this money through deduction of expenses in a business or something like that. Now, if you don't have a business, where you could put that in and take it as a deduction and spread it up, I don't know what the number of years is, 5, 6, 7 years. You'd have to research that. But that's a lot of money you could deduct and essentially end up paying zero tax if you're filing the conventional way. Now, the other thing you can do, this is one of my favorite ideas, is take the award instrument And you remember you recorded a notice of foreign judgment, and you've done maybe a few other things, but at the minimum, just the notice of foreign judgment, and maybe you did a UCC1 on it, just to create an additional recording of it. Then you could sell or assign the judgment to a judgment buyer who wants to collect and or use the tax deduction benefit from that instrument. Now, they're not going to pay you face value. They might pay you a third or half of its value. But that's cash you can receive. Okay, and then, I'm not going to tell you how that impacts you tax-wise because I don't know. But it's cash you definitely have access to. And you could take that cash and either, if the house is still around, pay it off, or pay off the car, or use it to buy a house and be free and clear, or pay off all your debt and buy a house. Get yourself into a positive position. Now, stay out of debt from that point on, please, as we teach. But here's a way to go out and get an award, take it, and monetize it several ways to win your house, to get back your house, to maybe get back your freedom, because that has a monetary value too. Or even just best yet, just have the cash to go buy what you need and live debt-free the rest of your life. Now that's how you can truly monetize an arbitration award. Again, these are just opinions based upon experience. Each situation is different. Each one has to be unique. You just need to understand this well enough to execute your own plan. So if you want to have greater discussions on this issue, you want to learn in more detail about how to do some of these things, find out what other people are doing along those lines, we have weekly discussion calls only for our premium members at yourlaw.org. It's a small monthly fee to be a member. Most people tell you it's well worth it, as compared to the alternative of sitting out there with nothing happening that's working in a positive way. The things we're showing you are things that are happening, and you can maybe find even better, more powerful ways to do this. But you have to have the foundation, and it helps you to stay engaged, continue studying. You could do far less worthwhile things with your time than to be studying the law, but I don't think so, because it affects every aspect of your life. Everybody lives with the law, or legal statutes, which is not God's law, it's man's law. You want to control these things. You want to control your contracts. That's what our systems are all about. It's only about controlling your contracts. It's not about hiding in a hole somewhere and not having anything. It's about controlling the contracts you come in with. And the arbitration is just one of those methods that we discussed. So hopefully you'll become a premium member. Let us know if we can help you. See you at urlaw.org.